Hello everyone, my name is Prajjwal Chauhan and I'm working as a legal intern with LEXIS and Company for the month of July. The topic for this video is anti-money laundering laws in India. The literal meaning of laundering is washing or cleaning dirty clothes. The term money laundering is used for cleaning dirty money. It is the disguising or concealing of illicit income in order to make it appear legitimate. Money laundering is being employed by launderers worldwide to conceal criminal activity associated with it, drugs, arms trafficking, terrorism, and extortion. Article 1 of EC Directive on Prevention of the Use of Financial System for the Purpose of Money Laundering 1991 defines the term money laundering as the conversion of property knowing that such property is derived from serious crime for the purpose of concealing or disguising the illicit origin of the property or of assisting any person who is involved in committing such an offense or offenses to evade the legal consequence of his action and the concealment or disguise of the true nature, source, location, disposition, movement, rights with respect to or honor of property, knowing that such property is derived from serious crime. The Financial Action Task Force on Money Laundering, FATF, an intergovernmental body established by G7 Summit in Paris in 1989 and responsible for settling global standards of anti-money laundering and combating finance of terrorism, defines money laundering as the processing of criminal proceeds to disguise their illegal origins or in order to legitimize the ill-gotten gains of the crime. India became the 34th country member of the Financial Action Task Force in 2010. India is also signatory to various United Nations conventions which deal with anti-money laundering and countering financing of terrorism. India has criminalized money laundering under both the Prevention of Money Laundering Act 2002 and amended in 2005 and 2009 and the Narcotics, Drugs and Psychotropic Substance Act 1985 as amended in 2001. The Prevention of Money Laundering Act 2002 is thought to be further amended by the Prevention of Money Laundering Amendment Bill 2011, hereinafter referred to as the bill, which has been introduced by the Minister of Finance, Mr. Pranab Mukherjee in Lok Sabha on December 27, 2011. The bill proposed to introduce the concept of corresponding law to link the provisions of Indian law with the laws of foreign countries. It also adds the concept of reporting entity, which would include a bank company, financial institution, intermediary, or a person carrying on a designated business or profession. The bill expands the definition of offense under money laundering to include activity like concealment, acquisition, possession, and use of proceeds of crime. The Prevention of Money Laundering Act 2002 levies a fine up to Rs 5 lakh. The bill proposed to remove this upper limit of fine. The bill seeks to provide for provisional attachment and confiscation of property of any person for a period of not exceeding 180 days if the authority has reason to believe that the offense of money laundering has taken place. The bill proposes to confer powers upon the director to call for records of transaction or any additional information that may be required for the purpose of investigation. The director may also make inquiries for non-compliance of the obligations of the reporting entities. The bill seeks to make the reporting entities designation directors or the boards and employees responsible for omission and commission in relation to the reporting obligations. The bill states that in the preceding relations to money laundering, the fund shall be presumed to be involved in the offense, unless proven otherwise. The bill proposes to provide for an appeal against the order of the appellate tribunal directly to Supreme Court within 60 days for the communication of the decision or the order of the appellate tribunal. The bill seeks to provide for the process of transfer of cases of the scheduled offences pending in a court which had taken cognizance of the offence to special court for trial. In addition, on receiving such cases, the special court shall proceed to deal with it from the stage at which it was committed. The bill also proposes to bring all the offences mentioned under Part A of its schedule to ensure that the monetary threshold do not apply to the offence of money laundering. Money laundering is a global menace that cannot be contained by any nation alone. The Prevention of Money Laundering Amendment Bill 2011 was necessitated in view of India being an important member of the Financial Action Task Force and to bring prevention of money laundering legislation on par with global norms. Thank you very much for listening patiently. Please like, share and subscribe to the channel.